Hello, everybody, and welcome to this webinar from Garden Court on preventing homelessness when asylum support ends. And it's a crucial topic, not least because of all the different policy decisions that we've seen from the Home Office over the last year about the amount of notice that asylum seekers in Home Office accommodation get. We have, as I say, a very large audience, which we're absolutely delighted about. And you are from all over the UK, from England, Wales and Scotland. The law on asylum support, the 1999 Immigration and Asylum Act, is of course applicable throughout the UK. But homelessness law, which we are discussing, is different in Scotland, Wales, and in England. So the seminar will concentrate on will entirely be homelessness law on England, but we hope that's still helpful for colleagues from Wales or from Scotland. My name is Liz Davies. I'm a barrister at Garden Court, specialising in housing law and in particular in homelessness and allocation of social housing law. Delighted to be joined today by a very, very experienced team. Two of our barristers, Matthew Ahluwalia and Georgie Rea, and we're very pleased indeed to be joined by Polly Glynn, solicitor from Dayton Pierce Glynn Solicitors. We're going to go through, in this order, the ending of asylum support, followed by how to make an application for homelessness assistance and what to expect, and then some practical tips, some perils to watch out for, and how to, if you're helping an asylum seeker, how to challenge local authorities effectively. If you're a local authority, what sort of challenges you might receive if you've not provided a decision either that a former asylum seeker wanted, or you've failed to comply with the law and the procedure. What I'm going to do is introduce our three speakers now, and then when they come to speak, we'll just move straight from one to the other and then deal with a little bit of housekeeping, and then they can start. So we will start in a moment with Matthew Ahluwalia. He's a specialist in public law, asylum support and housing as a barrister at Garden Court. He's an very experienced volunteer with Asylum Support Appeals Project, ASAB, and we know that ASAT are joining us today. And before he joined Garden Court, he worked at Public Law Project and also at Z2K, the advice charity. And Garden Court as a whole has benefited from Matt bringing his experiences at PLP and Z2K to us. He's going to talk about the ending of asylum support. He apologises because he is due in court at 2 o'clock. So when he has finished speaking, he will have to end. And if there are questions that relate to his talk, either we will try and deal with them, or if necessary, you can email them in, and Matt doesn't mind responding to a couple on the email. Our second speaker will be Georgie Rea. She's a barrister at Garden Court, specialising in public law, immigration, housing and community care, with experience in judicial review, homelessness appeals and tribunal work. So you see, we've got real crossover experience here. It's fantastic. She's going to pick up the baton from Matt with applications for homelessness assistance and how to achieve a seamless transition from Home Office accommodation to local authority assistance and accommodation. And then our third speaker, we're absolutely delighted to be joined by Polly Glynn. She is the founder and senior partner of Dayton Pierce Glynn Solicitors, who are an absolutely top-ranked firm specialising in public law. Part of what Polly does is the PAP project, Pre-Action Protocol project, which provides training and supervision to frontline organisations so that they can challenge decisions made by government or local government. And that's the name PAP, Pre-Action Protocol Letters. And its strapline is using law without lawyers, which I shouldn't cheer, because obviously if that happened all the time, some of us would be out of a living, but actually is something that society should aspire to. So it's an excellent strapline. And she's going to talk us through common problems and how to overcome them. On that basis, I don't think I've got anything else to say, and I'm going to hand over to Matt. Matt, all yours.
What I'm going to do is focus on the sort of appeal rights part of asylum support, really on the basis that there will be occasions where somebody who should be in receipt of asylum support has that support terminated, maybe prematurely, or their application is rejected for whatever reason. And of course, it's only refugees or those granted humanitarian protection or those other categories of people who are deemed to be eligible for homelessness who will actually be able to get support from local authorities under Part 7 of the 1996 Housing Act. So what I'm focusing on is those who are still asylum seekers, and yeah, just giving a very short overview of when an appeal rights may arise in the asylum support context. First thing I wanted to just flag is something that you might be familiar with, and which Liz has alluded to, which is that there has been a announcement about a change of policy in terms of what's referred to in the sector as the move on period. So that'd be the period when a asylum seeker is told that they have refugee status. Great news, obviously, but it means that their asylum support, including accommodation, if they've got it, will come to an end. And until now, that period has been 28 days. 28 days notice when the support will come to an end. That 28 days is often not enough time for somebody who's newly been granted refugee status to sort everything out that they might need to do to move on from asylum support, accommodation, and subsistence payments. It's often not enough time, for example, to sort out getting a bank account, or applying for universal credit, or sorting out accommodation, whether that's trying to do that themselves or with assistance from a local authority. And so the extension of that time from 28 days to 56 days is seems to me a pretty welcome move. It's a period that's been campaigned for some years, I think, and it's also in line with, as Georgie's going to go through, the period in which somebody may be threatened with homelessness under the Housing Act, and therefore entitled to the prevention duty. So hopefully that will provide a little bit more assistance in terms of sure that those who've been recently granted refugee status don't then find themselves homeless because they haven't had enough time. So that's something to keep an eye on. That announcement is that it's this extended move on period is going to be on a trial basis until June, and then we'll see how it goes. So something to definitely bear in mind if you are helping refugees who are in that position. What I wanted to go through, as I say, was just a bit of an overview of appeal rights and when somebody may have recourse to the Asylum Support Tribunal, as opposed to, say, the remedies under the 96 Housing Act for somebody who's trying to get homeless assistance. Essentially, there's broadly 4 categories in which asylum support may end early, as opposed to somebody making an application which is just rejected. So probably the one that's most of concern is where somebody is no longer considered an asylum seeker and so is ineligible for Section 95 support. Obviously, if the reason they're no longer considered asylum seekers is because they've been granted their refugee status, and that's not necessarily any support early. But if the asylum seeker doesn't have notification of that decision, then it may be premature to end that support. And on withdrawing claims, just worth bearing in mind that there's been quite a lot of appeals in the Asylum Support Tribunal on the jurisdiction of that tribunal to determine whether it can hear appeals about withdrawn claims. And the position is that for the most part it can. And so the tribunal will look at whether the decision to treat a claim as having been withdrawn. The tribunal will accept jurisdiction on those appeals and will look into whether, for example, the Home Office has met their own policy in treating a claim as having been withdrawn. As for destitution, those appeals are basically the same as if the claim for asylum support had been rejected in the first place. And likewise, breaches of conditions can also be considered in appeals in the Asylum Support Tribunal. So just as a reminder of the key terms that I've just referred to, asylum seeker broadly is somebody who's made a claim for asylum which has been recorded as such, but which has not been determined yet. That includes somebody who's going through the appeal system. So that, I suppose, might be another way in which somebody who is an asylum seeker may have their support ended prematurely if they've lodged an in-time appeal, but that hasn't been recognised or picked up on by the Home Office. And so they've got an appeal ongoing, they're still an asylum seeker, but the Home Office hasn't appreciated that in the context of support. And destitution is just worth reminding ourselves about, because obviously it doesn't come up in the homelessness context under the 96 Housing Act. But destitution in asylum support language is where somebody does not have either adequate accommodation or they do have accommodation, but they cannot meet their other essential living needs. So it's either or test. You may have adequate accommodation, but you don't have any access to any money, for example. And there's further details on how you assess destitution in the regulations and also in the Home Office guidance. appeal rights in the asylum support system are set out in section 103 of the 99 Immigration and Asylum Act. So it's all quite sort of nicely self-contained there, really. So if somebody does not qualify, if the Secretary of State decides to stop providing support, and that applies to both Section 95 and Section 4 support. Thank you. So just a little bit of an overview of what happens at the tribunal, because I appreciate that it may seem like asylum support is a bit of a niche area, even within social security law or public law. But as we're going to see throughout the discussion, and as some of you are probably intimately familiar with, asylum support does cut across so many areas of what we do as civil legal aid practitioners. So I think it is worth just having a short overview, if for those who maybe aren't so familiar, and maybe a bit of a refresher for those who haven't visited East India for a little while. So the Asylum Support Tribunal is actually part of the Social Entitlement Chamber. So it's the same area of the tribunal that covers other welfare benefits, so things like ESA and PIP and universal credit. So it's the same tribunal procedure rules, albeit with a much shorter timetable for asylum support, for obvious reasons, really, because the appellants are going to be destitute, and so there's a significant and real need for any appeals to be determined as quickly as possible, whilst making sure that both sides can fairly participate. The only live venue in which appeals are heard is at a place called Import Building, which is by East India on the DLR in East London. You can have appeals heard by CVP, which the tribunal was quite good at during the pandemic, but you will have to persuade the tribunal that it's appropriate to have a remote hearing as opposed to a live in-person one. So, for example, if the appellant cannot make it for travel reasons or for health reasons, and if they do need to travel, then the Home Office will pay for expenses. I've put on paper that preparing for asylum support is in scope. In practice, I don't think anybody does do this as part of their legal aid practice anymore. And even if they did advocacy at the tribunal, I don't think it's covered. So it's only really legal help that you could get for preparing for an appeal. And what, in my experience, seems to be the norm is that where somebody does need support that can't be provided by their caseworker or their solicitor who's doing the substantive immigration case, where possible, clients could be referred to the Asylum Support Appeals Project, who do really, really fantastic and important work at that tribunal. And if anybody's not familiar with ASAP and how they take referrals, really recommend visiting their website and getting in touch and seeing if you can get involved, because it's really important work. And the support that the client will get can be really valuable. One thing I wanted to note as well, just on the procedure rules, is that whilst the notice of appeal needs to be received pretty quickly, so within 3 days of the date of the decision under challenge, in practice, if you've got a good reason for needing a bit longer, the tribunal is usually quite accommodating, but you just need to explain why you need longer and why you're late. In terms of what the tribunal can do, essentially they can allow the appeal and either make their own decision or remit back to the Home Office. Obviously better if you can possibly ask for the tribunal to make their own decision. It will depend on the context, really. And of course, the tribunal can dismiss the appeal. And if that happens, there's no upper tribunal to appeal to. And so if client thinks, or their representative thinks there's an error of law in the way that the Asylum Support Tribunal has made the decision, the next stage is judicial review rather than upper tribunal. But in practice, it seems like most applicants will be able to reapply with fresh evidence, which is likely to be a better remedy in most cases, because they can argue that there's a material change of circumstance, and so the application can be reconsidered. On average, it takes usually about 2 or 3 weeks from the appeal being lodged to the hearing being determined. Unlike other social security tribunals, the Asylum Support Tribunal is quite good at publishing judgments, and I've put a link in the slides which you're going to get to where you can peruse them at your leisure. Thanks very much. So when is there not a right of appeal in the asylum support context? Some of those points are maybe more familiar to you than others. So the first 3 in particular, I think a lot of us in attendance will be familiar with. So where Section 98 has been discontinued, the client wants to challenge the suitability or adequacy of their accommodation, or where there's been a delay in providing support or processing applications, cases that we certainly see in chambers all the time. Where things might get a little bit more complicated is where the Secretary of State are saying that they aren't rejecting the application as such in terms of the merits, but they're refusing to entertain it, maybe because the wrong application form was used or because it's a repeat application with no change. But sometimes you get decisions which actually do amount to substantive considerations of applications. And in particular, the decisions made under Section 57 of the 2002 Nationality, Immigration and Asylum Act, which I'm going to talk about now. Just as a reminder, what Section 57 did was amended the one of the schedules to the 99 Act, and says that the Secretary of State can decline to entertain application for asylum support where the Secretary of State is not satisfied that the information provided by the applicant is complete or accurate, or that the applicant is cooperating with inquiries. What that means in practice in the tribunal is what I'm going to talk about next. So, as I say, sometimes what you need to do is look at these decisions quite carefully and look at the substance of what the letters say, and not just immediately assume that, because a heading of a letter says we're not entertaining under Section 57, that that's actually what the letter does or what the decision does. Because sometimes the wording of the decision letters actually does contain a substantive consideration of the merits. And what I've done in the last couple of slides I've got is just set out some examples from the tribunal case law on how the tribunal has assessed some of these decisions. One case in particular, the judge emphasised that what Section 57 says is about providing information as opposed to providing evidence. So an applicant may be able to explain something, even if they don't have corroborating evidence about something. And so it's important to be aware of that difference. Likewise, in terms of, if a decision letter says something about the credibility of the evidence or the information that's provided, then that is more likely to point to a substantive determination as opposed to a refusal to entertain. The cases that I've listed here are on a kind of similar sort of trend to that. So where the applicant hasn't been believed about providing evidence or information that they provided, then that's arguably a determination of merits as opposed to refusing to entertain. That second example is maybe a little bit more extreme, because the letter in that case did not say expressly that they were declining to entertain, but nevertheless tried to rely on Section 57. And in fact, the letter said in that case that the applicant had failed to satisfy us of destitution, which seems to quite clearly point to a substantive consideration. And in another case, the Home Office weren't able to rely on Section 57 because the appellant in that case had been found by the tribunal to have responded to inquiries. And so there wasn't a basis to say that Section 57 applied. So as I say, all those cases are just about making sure that the substance of the decision letters is what's being considered and not just the headline. And I think this is me done. Just as I say, you're going to get all these slides afterwards, but just some links and references to resources. I've included the advice line for ASAP there, which is available to advisors and professionals as opposed to lay clients. So do give them a call if you've got a question about a case. And then the two textbooks there are both brilliant resources. And yeah, if there's any sort of particular point about practice or procedure, the answer is probably in those books. But as I say, if my colleagues can't field the questions after I've disappeared, then yeah, do feel free to get in touch and I'll do my best. I think that's me done. Thanks so much for indulging me. And I'm sorry I can't stick around for the end, but yeah, enjoy the rest of the session. Thank you.
Matt, thank you very much indeed. So we're moving on to Georgie Rea, and we should have George's slides up.
So obviously we've just had that really insightful talk from Matt about how to challenge the ending of asylum support. And I'm going to be looking at moving on from asylum accommodation and how local authorities' duties can help newly recognised refugees specifically to access support and to prevent homelessness when asylum support ends. I'm going to be taking a high-level look at duties owed by local authorities in England, and then I'm going to be looking in more detail at the relevant tests an applicant for assistance needs to meet in order to access support, both through the lens of those leaving Home Office accommodation. I'm conscious, as Liz said, that some of the things I'll be addressing differ slightly in Wales and Scotland, but please do ask at the end or by email if you have any questions in that regard. So yes, starting with the duties, the cornerstone of homelessness support are the prevention and relief duties placed on local authorities. And these duties are triggered when someone who is eligible presents to the local authority as either facing the threat of homelessness or already being homeless. Refugees are eligible for homelessness support once their asylum claim has been positively determined. And when these duties are engaged, local authorities are legally obliged to assist the person's housing, to assess the person's housing needs and develop personalised housing plans. So first, the prevention duty under Section 195 of the Housing Act focuses on stopping homelessness before it occurs, while the relief duty under Section 189B comes into play when someone is already homeless. And crucially, this can include providing interim accommodation whilst local authorities consider the application. When someone presents as homeless, local authorities have a responsibility to provide emergency accommodation if there is reason to believe that they are homeless and eligible for assistance and have a priority need. It's important to note that this is a designedly low threshold, meaning that local authorities should err on the side of caution and not delay providing emergency housing. I'll look in more detail at priority need later. The prevention duty is activated when someone is at risk of homelessness in the near future, specifically within 56 days. So we can see here that the 56 days that the Home Office now has for the move on time lines up very well with the scheme under the Housing Act. So someone who presents to a local authority as threatened with homelessness, as soon as they receive notification of their asylum decision, should be able to access support before they have to leave their existing accommodation under the new move-on period. The local authority must conduct a housing needs assessment and continue to work with support services to prevent further homelessness, and the individual has a right to request a review of the decision to end any prevention work. So the prevention duty can only be ended after the 56 days or in specified circumstances, for example, where a person actually becomes homeless. And we're going to look in the second half of my presentation at when people may, by choice, leave their asylum accommodation before the 56 days. So once someone is found to be homeless and eligible for assistance, the relief duty kicks in. And this requires local authorities to take reasonable steps to help them secure accommodation for a minimum of 6 months, with all actions guided by the individual's housing assessment and personalised housing plan. And this is a key period to help secure stability for new refugees. Again, the relief duty ends 56 days from when it was accepted if the local authority is satisfied that the applicant is in priority need and not homeless intentionally. To qualify for the main housing duty, an applicant must be homeless, eligible for assistance, in priority need, and not intentionally homeless. I'll be looking at intentional homeless in more detail in the latter half of this presentation. The main duty is owed by the local authority to which the applicant was made, unless a local connection referral is made to another area. And that's, I'll also be looking at local connection tests. Personal housing plans are a critical element of the process. PHPs help identify suitable housing options, secure financial assistance for deposits and rent, develop essential skills for managing a tenancy, and aim to address underlying issues that contribute to homelessness. And these plans are a central point of support for a person and key to the success of their move on from Home Office accommodation as a newly recognised refugee. So I appreciate that was a very high level look at the duties that will be owed to a person who presents as homeless. And you've probably noticed that the duties owed depend on the stage of the application and the person's situation. The authority might have different duties depending on if the person is homeless or threatened with homelessness, eligible based on their immigration status, in priority need, or intentionally homeless. So I'm going to have a look at some of those things now. So a person does not have to be sleeping rough to be legally homeless. They can be homeless if their accommodation is not reasonable for them to occupy, or if they don't have a legal right to occupy it. And likewise, a person is threatened with homelessness if they will likely become homeless within 56 days. And this is where we really get into seeing how the test might be difficult or have specific elements when it comes to newly recognised refugees. So certain individuals are deemed to have a priority need for accommodation and therefore will be able to access Section 188 interim accommodation as a result. Whilst there are specific categories of people who will automatically be recognised as having a priority need, such as care leavers, and I've given a few other examples there, others have to demonstrate their need through reference to vulnerability. And the test that we get from HOTAC is whether the person would be significantly more vulnerable than an ordinary person would be if they became homeless. So asylum seekers are not an automatically recognised category of person who would be in priority need. But many asylum seekers will have a history of trafficking and modern slavery, which the Homeless Code of Guidance indicates at Chapter 8.44, and that can make them vulnerable in the HOTAC sense. Beyond this, I've included authority that local authorities should consider whether someone with refugee status might be vulnerable as a result of their physical or mental health or history of trauma, and whether they've already accessed any support in the UK. Local connection test is relevant at the relief stage, as a local authority can refer someone to another authority area if they're satisfied that the applicant is homeless and eligible for assistance, but does not have a connection to the area where they have applied for support. Generally, if a person has been provided with accommodation under Section 95 in a particular area, they have a local connection to that area. However, if they have been in multiple areas, the connection is within the area they have most recently received Section 95 accommodation, and this can affect which local authority owes the main housing duty, and the authority can refer an applicant to an area where they do have a local connection. Note there that there is an exception if people were accommodated in accommodation centres. So that would be, for example, like the Bibby Stockholm, or when people were accommodated in Napier Barracks. That doesn't give you the local connection for the purposes of Section 199. So the Homelessness Code of Guidance notes a former asylum seeker who has a local connection with a district because they were provided with accommodation under Section 95 may also have a local connection elsewhere for some other reason, for example, because of employment or family associations, and that could be the basis of a referral to a different local authority. So just looking here at the Bibby Stockholm, which I've mentioned. So it was moored in Dorset and was used to house asylum seekers from 2023 onwards, but it has now, and I'm sure many people will be glad to hear, been decommissioned, and the lease will be ending in January 2025. I think the attitude of Dorset Council towards the barge being there demonstrates the gatekeeping that we see when people leave asylum accommodation. So on their website, Dorset Council state that they had received a written undertaking from the Home Office that no notices of asylum, so grants of refugee status, would be issued to anyone on board the barge, so that they wouldn't be adding a burden to Dorset's housing list. I was involved in a few cases where the Home Office mistakenly issued positive asylum decisions to people on board, triggering the then 28-day move-on period. And that meant that refugees were either moved to new areas whilst the clock was already ticking, or struggled to present to Dorset, or didn't have enough time within a new area to really properly access support. But as of the 6th of December this year, all residents have been moved off the barge, and none of the residents have been moved from the Bibby Stockholm to addresses in the Dorset Council area. We've also got another quote from Dorset Council here, where they explicitly stated that if an asylum seeker did present themselves requiring housing, they would be treated as any other single adult male, which given current selection criteria, would make them the least likely to be offered housing compared to local families, the elderly, those with disabilities, etc. So this is an incredibly reductive statement regarding the real legal test for priority need, but exemplifies the kind of gatekeeping we see and expect to see towards refugees presenting as homeless. It's important to advise clients, therefore, to gather as much relevant information from their asylum claim as possible, as it may be the case that they will already have some medical evidence or a psychiatric report or evidence of past trauma that they can show to a local authority, and at the very least show that they meet the threshold of reason to believe that they are in priority need, because they would be significantly more vulnerable than the ordinary person if they became homeless, despite being reductive, a single adult male. So a person is considered intentionally homeless if they deliberately did or failed to do something that caused them to lose accommodation. That would be reasonable for them to continue to occupy. Crucially, they need to be aware of the relevant facts before taking or failing to take any action, as this affects access to the main housing duty. We think it's unlikely that a person will be determined intentionally homeless by leaving asylum support early for example, if they want to go to a different area and be nearer their family before presenting as homeless. Looking at the test in Harley, an applicant for support would have to argue that their homelessness at the time of the authority's decision was not caused by them leaving the Section 95 accommodation, but was caused by the support inevitably ending and or being no longer reasonable for them to continue to occupy. When a local authority offers temporary or permanent housing, individuals have a right to request an internal review of its suitability, even if they accept the offer. If that review finds the accommodation unsuitable, the local authority is under a duty to provide a suitable alternative. And this can be particularly important for refugees who may have very small support networks and need to be in accommodation which allows them to access key services. Just to finish up, I've included 2 cases here that show how the locations of accommodation must be considered holistically, and if an assessment or a personal housing plan does not contain relevant medical or social evidence, then that assessment may be flawed, resulting in an offer of unsuitable accommodation. So I now believe that Penny will be providing more tips and insight into how refugees in particular might encounter issues at each stage of this process, and she should be offering guidance on how to make the most of the support that is available through the PAC project and otherwise. So thank you very much, everyone, for your time.
Georgie, excellent. Thank you very much indeed. And our last speaker is Polly, who's going to talk about work from the coalface. Polly.
Thank you very much. Some of this is a bit repetitive, but it's from my position as a solicitor dealing with people day to day, as opposed from the sort of technical legal side of it. So the issue is about when you get refugee status, you're asked to leave the accommodation within 56 days. And I think what I always advise clients is that this then is a period of huge uncertainty, and it's quite stressful. And I think it's really useful to land that with people who get refugee status, because otherwise it can be very difficult after years of uncertainty about what's going to happen with your status, and you suddenly get this, and it can be very stressful, suddenly realizing that this is just the beginning of something that will be very stressful for at least a few months. So this just tells you about when the asylum support is due to end, and repeats what the previous people have said about it used to be 28 days, which we all got very cross about. And now the government has announced it's going to be 56 days for a bit. Presumably they're not going to go back on that. There remains the issue of whether 56 days is enough time to find accommodation. And in my view, often it isn't. That's because it takes time to sort out your universal credit claim. You have to get a bank account. There's e-visas, which are going to create additional complexity and problems for people. And then it's hugely difficult to find accommodation without a deposit, without references for a landlord, without a job, without ongoing benefits, and without contacts. Often refugees are victims of trafficking or trauma survivors, or vulnerable in other ways. And that's all on top of somebody trying to get into training and employment and getting their life together for the first time that they're allowed to. My concern is about what happens when the 56 days isn't long enough. And my concern is that historically, when it was 28 days, but I think that the issue will remain when it's 56 days, is that we're seeing people who are street homeless. So they've just been granted refugee status, and then they end up street homeless, which is the very worst way to start your path into being a sort of active member of our society. So you're advising somebody who's just been granted refugee status on what steps should you advise them to take. The first thing I advise them is about what the process is going to end up with, what to expect when you make a housing application. So you apply as homeless to the local authority. The local authority has to make inquiries into your application and do a housing assessment about what your family consists of, what you're like, whether you have priority need. They then have the local authority then have an absolute duty to provide accommodation if you may be in priority need. So if you're a refugee and you may be in priority need, that's a duty. That's likely to be in B&B or hostel type accommodation. And again, really useful to land that with people right at the beginning. The local authority always has a duty to prepare a personalised housing plan to identify steps the applicant to fund accommodation and the steps the local authority can take too. Then, if somebody is deemed to be in priority need, there's a main housing duty. And that means that they will be provided with suitable accommodation. There's no duties after 56 days for other people, but there is a power to provide accommodation. So only if you're owed main housing duties, you're provided with suitable accommodation. And also, just to flag up, that's likely to be privately rented accommodation. And for single people, it can be a shared flat. So it's just really useful to kind of, I think, when you're advising somebody, to get them to understand what they're aiming for and what's going to happen. It's not going to be a council flat. That's, it's not going to end up being a council flat anytime soon. And that's quite useful for people to understand. Next slide, please. So for applicants not in priority need, the assessment and personal housing plan is the best and maybe the only option to get accommodation. Sorry, the next slide, please. So then, looking at your first steps, the practical steps that you must take. First thing, apply as homeless to the local authority. So legally, this can be done pretty much any way. You can just phone up and that's an application as homeless. But really, to make things simpler, write a letter for somebody to go to the homeless persons unit, explaining the name and details of everyone in the family, when they've been asked to leave the accommodation, explain in the letter that they're presenting as homeless, identify any reasons why they may be in priority need. If there are any medical reports, attach those. Ask for a personal housing plan to be prepared urgently, and get your clients to take any proof of ID, status, benefit claims, notice to quit with them to make that application as smooth as possible. Georgie has just advised that it's fine to leave the Home Office accommodation early. I would be a bit more cautious, and I would say to somebody, stay until you are absolutely asked to leave, because you don't want to be litigating about intentional homelessness here. If they don't have the medical information, but you know that there is some available, just still get them to present as homeless as quickly as possible. So if you hear somebody's got refugee status, the first thing you do is say, next day, go and present as homeless to the local authority. Also, just as a reminder, apply for universal credit, and also ask to consider an advance claim for universal credit to get your benefit claims sorted out as quickly as possible. So then if you may be in priority need, then the local authority has a duty to provide you with accommodation while they conduct inquiries into your application. And that could be shared accommodation, or it could be a B&B. So for people without children, it'd be useful to have medical evidence of vulnerability. The issue here is that gatekeeping is completely rife. So I've had clients who have gone along with groups of people, all have been granted status on the same day, and the local authority has turned them all away because they're single men. That kind of decision-making is challengeable by judicial review, and there's a PAP on that on the PAP project website, if anyone's signed up to that scheme. Local connection provisions apply, so there's no point in, if you have arrived in the UK, being accommodated in Manchester and decide you want to come down to London for the first time, you're going to get referred back to Manchester. So it's as well to know that, rather than sort of go around the houses on that. But it's really important to remember that if you have been accommodated somewhere else and then get moved to say Manchester, if you've already got a local connection in the first area, then that isn't trumped by the fact that you also have a local connection to Manchester, if that's clear. So I've said priority need is a huge area, and Georgie has usefully dealt with it, so I won't say anything more about that. I've referred you to the Shelter website, which I find a source of fontable good knowledge about the housing law, so it's worth looking at that, and also the Homelessness Code of Guidance. So then what happens if you're homeless and not in priority need? Local authorities got a duty to conduct a housing needs assessment and prepare a personal housing plan. And I think that this is absolutely crucial for applicants who are not in priority need. And I think it's one of those bits of law that seems to be being ignored by everybody. The guidance issued by the government anticipates that the housing plan will result in accommodation. And currently that isn't happening. And so I'm really interested to see what's going on there, because the whole act is predisposed to the fact that we're going to get your housing plan and it's going to support you, and the local authority will give you additional support if you need it, and that will end up with you being in accommodation. But actually what we're seeing is refugees sleeping on the streets. So there's an issue there which I'm very interested in looking at. So what should be in an assessment and personal housing plan? It should be an assessment of circumstances and your needs. It should be realistic. It should take account of local housing markets and the availability of relevant support services and the individual's needs and wishes. But it will have mandatory steps that people have to take, and it's really, really important that they do take those steps. And then it will have other steps that the applicant may want to take, sensible to take those steps too. What I think is really interesting here is the guidance makes clear, as part of the plan, the Housing Department can provide support to applicants, whether financial or otherwise, to access privately rented accommodation and help or secure immediate safe places for people who are sleeping rough or at high risk of sleeping rough. If the personal housing plan doesn't contain those provisions, then I think you should request a review or look at challenging it in other ways. And I think, again, this is something that people are missing generally, and that's why we're seeing people sleep homeless. This is just a summary. Your advice when someone's about to be made homeless, so they've got their refugee status, they've got their notice to quit. All cases, make sure they've got a notice to quit, advise them to claim benefits, follow up the claims as quickly as possible, try to open a bank account, to make sure that the e-visa is working properly, to get medical evidence concerning accommodation to hand, and then apply as homeless. Two options: they may be in priority need. The local authority should be providing them with interim accommodation. If they're not, you have to judicially review that, so PAP it first. And as I said, there's a PAP on the website about that. If they get a decision that they're not in priority need, and you think that they may be, then refer quickly to solicitors, because there are short timescales there. If your client is probably not in priority need, then ask the local authority to accept an application, do an assessment, prepare a personal housing plan. If they don't do this straight away, then again, you should PAP this. And again, we'll put a PAP on the website about that. And then consider a challenge if the assistance provided doesn't or isn't likely to result in the provision of accommodation. And this is my very, very quick summary of the summary that I've just given, which is, I don't think refugees should be street homeless, and I think the law prevents that from happening, and we just need to utilise the law a bit better to make that clear. That's it.
Polly, thank you very much. That, along with law without lawyers, refugees should not be street homeless, is a mantra that we should all have at the front of our minds. And the other thing I wanted to say is the point about the assessment of housing needs and personal housing plan is absolutely key. That's supposed to be the roadmap for somebody being helped to find their own accommodation, and therefore proper help given to people who are not going to be in priority need, as well as accommodation for those in priority need. I think we have time for two questions. I've got one for Georgie and one for Polly. So given that Polly was speaking, I'm going to ask Georgie to answer first, and I'll just read it out. So it is this: if living in one local authority and then dispersed to a new local authority just before being granted leave to remain, can a request for local connection be made with the previous place under special circumstances? Georgie.
Thank you very much. So one of my slides did have a bit more detail on this specific question, and those will be circulated. It's the slide entitled Local Connection Homelessness Code of Guidance. So essentially, section 1996 provides that a person has a local connection with the district that they were provided section 95 accommodation within. However, and this is a really important exception, under section 1997, they won't have a local connection if they have subsequently been provided with section 95 accommodation in a different area. So where someone granted refugee status has been provided with section 95 accommodation in more than one area, the local connection is with the most recent area that they were provided accommodation within. The Homeless Code of Guidance does provide a bit more help on this. So the local connection with the most recent district, that would be under section 1996, doesn't override local connections by virtue of other reasons. So I think what we'd be looking to do, as you suggested, is trying to establish a special reason for the previous connection, or if there was a family connection, that might be a helpful way to get referred back to your old local authority. But the position really is that your local connection is with your most recent accommodation, and that might seem incredibly unfair, where you've only maybe been moved a couple of days prior to being granted refugee status. So it's always worth exploring special circumstances and seeing if that's a way that you could establish going back. But there is that express provision in section 1997. I hope that helps. Thank you.
Georgie, thanks. I'm going to confess that the incredibly unfairness is partly down to me, because about 20 years ago I was involved in a case of asylum seekers leaving accommodation in Glasgow and coming to London when they got their refugee status. And the House of Lords held that asylum support accommodation was not residence of your own choice, which was fantastic. So Parliament then legislated to put in subsection 6 and 7 in section 99 to provide for the deemed local connection under section 95. So my apologies for that to everybody. I think we've got time for one. There have been a number of questions, but I'm aware that at 2 o'clock you'll all be back to advising your clients. So I'm going to take one more, and that's for Polly. And it's very short, but it's very on point, and it's how exactly do you challenge a personal housing plan that is not adequate? Polly.
You have to request a review, and then you can appeal it on a ground of law. But I'm interested in looking at that in a bit more detail, really, because it seems to me that there may be other ways we could challenge that. So I would be interested to hear from people with clients who are not in priority need and who are facing street homelessness, because I think that there is more sort of work around that, about how to ensure that the local authorities do exercise their powers to provide assistance in those circumstances.
Mm, mm. And it may be that there are judicial reviews around other elements of the personal housing plan that can't be subject to the review. So my apologies. There are lots of questions on the Q&A. That always happens with our webinars, and I'm sure speakers will be pleased to answer if you do want to contact them, although I'm not encouraging too much contact. But you know, if you want a specific answer, then you can contact us. Can I now draw this to a close? First of all, thank everybody for attending and giving up your lunch hour. We do appreciate your feedback. And when the Zoom finishes, then a feedback form will pop up. So do fill that in if you're able to. As we've said throughout the webinar, then there will be a link to the recording and the slides sent out after the webinar. This is our last webinar for 2024, but we have a programme of webinars for 2025. We do frequent webinars. You can find them on our website, but the one I want to flag up is early in January, on the 9th of January at 5:30, and it's on discrimination and housing waiting lists. And we've got two speakers. We've got Michael Sprack, who is counsel in the recent case of Begum and Tower Hamlets, which was a JR, and Nick Barno, counsel in the recent JR of RR and Enfield. And both of those cases are about the extent to which there may be discrimination where homeless applicants are in Section 193 accommodation and they're waiting for suitable accommodation. So they're waiting to be moved to suitable accommodation, or they're waiting for an allocation and they want to challenge the distribution of points for the allocation in relation to discrimination and the Equality Act. So those are two quite exciting cases, which Mike and Nick will be talking about on the 9th of November. So please do sign up for that and for any other webinars that you see on our website. if we were all in person, I would say please thank the speakers in the usual way, but of course you can't do that. But I do see that there are thanks on the Q&A. So thank you very much indeed for expressing your thanks to our speakers. And they do give up their time, not only their lunchtime, but also, of course, their time in preparing their slides and their talks. And then finally, just to say thank you all very much. I hope that you will all manage to get something of a break over Christmas and New Year, and you'd all deserve a break because there will be a lot to do in 2025 around the areas of asylum support and homelessness. So you all need a break in order to recharge your batteries. Thank you very much, and get back to advising asylum seekers. Thank you.